My name is Evie Exme, and I am a senior at Convent of the Sacred Heart, and I'm part of the Teagle group. And today I'd like to interview you. You are a professor at Columbia University, and you have experience as a trial attorney, and you've argued before the U.S. Supreme Court and the U.S. Court of Appeals in numerous cases, and so it's my honor to be here in front of you. Why do you think there's a discrepancy between the states on voting rights requirements and laws? Because in New York it may be one thing, in Philadelphia it's something else, in Alabama it's something else.
Well, yeah, there are a lot of reasons. I mean, one is, you may know, our system here in the United States is a federal system, and a system of federalism, which means that the federal government is empowered in some ways by the Constitution to have exclusive jurisdiction over certain things. But this is a nation that is composed of 50 states, and those 50 states have their own sovereigns. And we have a deep history of discrimination in electoral politics and voting rights in this country. African Americans were denied the right to vote in totality until the post-Civil War years and the passage of the 15th Amendment. And that happened in 1870, but then, of course, the right to vote was once again rendered effectively meaningless because of violence in the South and aimed at preventing black folks from voting. And of course, even the 15th Amendment didn't empower black women to vote. That was just black men. Women didn't get the right to vote until 1919. So there were all kinds of things that were done to keep black folks from voting right on up through the enactment of the Voting Rights Act in 1965, which I always say was bought and paid for in blood. It has required over the years jurisdictions with a history of discrimination to get approval for any changes in electoral politics. They go to either the Justice Department, Civil Rights Division, or to a federal district court in Washington, D.C. for approval. The idea is that we've not yet reached a point where those institutions can be relied upon to enact electoral changes in ways that are non-discriminatory. Now, many people say that so long ago that it's not relevant. They say that therefore that this law should be unconstitutional, the extension of Section 5 of the Voting Rights Act, and that's what's at issue in the Shelby County case.
What's your opinion on that? Do you think that Section 5 it's so far in the past that it's not reliable anymore, that the South and the states that are under Section 5 in particular should be allowed to make their own choices without influence by the federal government?
Well, I have a couple of responses. I mean, one is I think there's still some work to be done by Section 5. I testified before Congress several times when we were trying to extend Section 5 of the Voting Rights Act. But also, we have numerous instances in recent years of discriminatory actions taken by some of these states that have been covered by Section 5. If the states feel like they are unfairly being retained under Section 5 coverage, there's part of the act that is called bailout, and they can go to federal court and say, we haven't had any problems, we haven't done anything wrong, hasn't been any violations for a number of years, let us out from underneath its coverage formula. I don't think it's as onerous a burden as some people might think it is. I think that we have another round to do. It's not that every jurisdiction that has problems is covered by Section 5, because it's primarily the South, the southern states, although not exclusively. Parts of New York City are covered, but they're covered because of language minority concerns. People being citizens who are not proficient in English still have the right to vote, and they should receive assistance. And so Section 5 covers parts of New York City. In the South, and in some other parts of the country, you've seen some of the problems if you've watched in recent years. Polling places being moved. The fact that many people, too many African Americans, have been incarcerated. They are denied the right to vote after incarceration. In states like Florida, were trying to purge people from the rolls, and they made a lot of mistakes. A lot of people who had never been incarcerated were being purged from the rolls, and so we've seen those kinds of practices Recently, we've been fighting voter ID laws, which a lot of people think are innocuous. And they're unnecessary because there isn't really a problem in this country with in-person voter fraud. But also, you see, they're unnecessary. The fact that they're being used essentially to keep certain people out, not only because they're Democrats, but because they're black and Latino. I think we still need to have Section 5, although this is a court that's very hostile to civil rights, and I think that there's a good chance it won't survive intact.
Do you think that the voter ID laws and the registration that is being required of many states, do you think that it's discriminatory, and if so, is it discriminating against people of color, or is it discriminating against the poor? Because I know a lot of them are requiring that, you know, you have to buy drivers, that you have to pay for this.
Yeah.
So, and if it is one or the other, do you think that there's a correlation that the poor tend to be people of color?
All that. I think all that. Yes, it has an impact upon poor people. Most Americans, it's true for me, having a driver's license is not a big deal. And many people say, so government ID, big deal. It can't cost that much. You ought to be able to get it easily. Almost everybody has one already. I say, think about Katrina. People saw the hurricane coming. Most people got out. And most people thought everybody would be able to get out. And yet, there were tens of thousands, if not more, people almost exclusively black and certainly poor who weren't able to get out. It's because we underestimate the depth of the impact of poverty, and poverty correlates very strongly with race. Getting a driver's license or a governmental ID, many people don't have them. Many poor people don't have them. And poor people have as much a right to vote as rich people. But also some of these voter ID laws, the people who are enacting them understand very well who's going to be impacted by it. And they do want to keep black folks out of the polls. Now, if you say that, they'll deny it. But they want to do it only because black folks disproportionately vote Democratic and they're trying to get an advantage of partisan. But also some of it is race motivated.
Is this a new movement? And if
voter
so,
ID?
Yeah.
Yes and no. It's new because it's the ID itself was not the vehicle through which people were being denied the right to vote or being challenged on exercising the right to vote. No, because it has the same effect, or a very similar effect, that the old laws had, which required people to pay a poll tax, to pay for going to the polls, for the right to vote. The impact is if you don't have the money, if you don't have the ability to take a trip, for example, if you live in a rural county, a long trip on a bus or to get a ride or something like that to somewhere where you have to get this ID, you may be effectively shut out of the exercising your right to vote. I often remind people that homeless people have the right to vote if they're American citizens. There's nothing in the Constitution that says that you have to have a home or a house in order to be able to vote. Yet many people think somehow or another that people who are homeless, people who are poor, somehow or another they don't count. And as the people in the civil rights movement used to say when they encourage people to exercise their right to vote, if you don't vote, you don't count. And that's true in the sense of exercising political power, and that's why people are trying to keep people away from the polls.
So why the disenfranchisement now?
Well, that's a good question. There's now, I think my best answer for that, look what happened in 2000. The presidential election that was disputed, it was so close.
Yeah.
It came down to a relatively small number of votes, who was going to be president of the United States. And of course, the outcome was really determined by the Supreme Court. George Bush in 2000 was selected, not elected. And people know now and understand how each vote counts. So that's one thing. The other thing I think is that there are some people in this country who fear the change that's going on. And the change is that the people who have been in the majority and who have had their hands on the levers of power are no longer exclusively exercising power anymore. And Frederick Douglass said power conceives nothing without a demand. Well, people don't give up power easily. Yeah. So in some respects, some of this is a dying gas, but they'll try their best to keep other people from participating in the political process in a way that empowers them.
So in your expert opinion, what do you think the Supreme Court will decide with Section 5? And do you think that it's still necessary? How necessary is it that we have this one part? And do you think that it'll just be Section 5 or the entire document?
Well, the entire Voting Rights Act is not up for grabs right now. It's very complicated. There's two big parts of the Act, Section 2 and Section 5. Section 2 protects minority group members from discrimination in the political process under certain circumstances. Section 5 is what's up for renewal. Every few years that has been renewed. And as you know, I think it's necessary for the reasons I've talked about already. If it is not renewed, what we're going to see is states being able to do the kinds of things that we've been talking about, whether we're talking about voter ID laws or moving polling places or trying to use felon incarceration status. We're not going to keep Section 5 forever. There's no question about it. You asked me what I think the outcome may be. Yeah. After many years of being a lawyer who's been working in federal cases and in the Supreme Court, the first thing I say is that it's a mistake to predict. You just don't know. A lot of people predicted that the Affordable Care Act, Obamacare, that was going to go down in flames, and then last term the Chief Justice voted in a way that surprised everybody. So with that caution, I will nonetheless engage in what's a fool's errand and say that this Supreme Court, very narrowly divided, 5-4 on issues of race, almost all of the cases therefore come down to what Justice Kennedy is going to do, Anthony Kennedy, because he's the swing vote. And Justice Kennedy has never voted to uphold any race-conscious measure that he's passed upon in his career on the bench. Never. Now, having said that, he has not gone as far as the more conservative justices on this court would go. And they would strike down almost all race-conscious measures as unconstitutional. He hasn't gone that far. He's refused, for example, to join Chief Justice Roberts and Justices Alito and Scalia and Thomas when in a case, two cases involving voluntary school integration, they said that was unconstitutional. So theoretically he leaves something alive, but it's a practical matter. Usually he votes to strike down whatever's before him. That doesn't augur well. My hope is that, being the swing justice, is he recognizes the gravity of that situation, and it's one thing to be one of 5 votes, for example, or 4 votes in dissent, against a race-conscious measure like the Michigan affirmative action cases in 2003. It's another thing to be the swing vote, take the country to the edge, look over the precipice, and then say, "Yeah, I'm jumping down there and taking us all down there." My hope is that he won't do that, but that's nothing more than hope. Hope is important, but our experiences with him have not been good when it comes to race cases, and so this term is a very important one. You have Shelby County, the Voting Rights Act, Section 5. You have Fisher involving admissions to colleges and universities, a process that you just went through. And there are 2 other cases that a lot of people aren't even watching. A Fair Housing Act case out of New Jersey, and next term another case involving affirmative action in higher education that comes from from Michigan. This is an opportunity for Chief Justice Roberts and the conservative justices to accomplish something that they've been trying to do for a long time, what I call the conservative project on race. And I'm deeply concerned about it, and voting rights, it's the crown jewel of the civil rights statute, so there's a lot to be concerned about.
Do you think that there's any hope that Justice Thomas may go the other way, because being a black man, he may see that maybe I don't want to go so conservative on this one? Is there any hope for that?
Part of me always wants to remain hopeful. Justice Thomas hasn't showed us one thing that should give us reason to be hopeful about which way he's going. The organization I worked for many years, the NAACP Legal Defense Fund, opposed the nomination of then Judge Thomas to the Supreme Court on the merits. At the time he was nominated, before any of the Anita Hill allegations became public. Unfortunately, two things happened. One, a lot of people, including a lot of black folks, said he's black and he will not betray us. He will, once he's on the court, he'll turn and he'll do the things that are necessary to protect the interests of African Americans. Justice Thomas is an African American who has a very conservative view, and his jurisprudence is more conservative than any other justice on that court, including Scalia. That's who he is. The time to oppose him was on the merits of his nomination, based upon his record, as the Legal Defense Fund did. The second thing that happened at the time was that many people, once the Anita Hill allegations came out, thought that, or acted as if, you didn't believe that he sexually harassed her, then he should be confirmed to the Supreme Court. If you believe he did, he shouldn't be confirmed. And everything else dropped out. And that was unfortunate, because there were lots of other issues that should have been thoroughly vetted. And a lot of black folks who thought that he was going to turn around have been deeply disappointed. Now, my own view, because there are a lot of people, particularly those who supported him at the time, who are really angry at him, and they say all kinds of terrible things about Justice Thomas. I don't do that. I think, some people say he's not intelligent. He's very intelligent. Some people call him all kinds of names. We oppose him, as I said, based on his record. No need for name calling. Some people say he's not black. Well, that's ridiculous. He's an African American from the African American experience, but has a deeply different view of the world and of jurisprudence and of the Constitution and of race issues than most African Americans, but certainly my views differ. And so I look at Justice Thomas and I say he's on the court. He's not going anywhere anytime soon, unless he or God wants him to. And it's not a vote that we're going to get. And so I don't worry about that a whole lot. We have to move on.
Do you think that there's a remedy that Congress could propose in order to resolve this issue and find a happy medium between those who support voter ID and those who oppose it?
Well, this Supreme Court has upheld voter ID laws in a case called Crawford versus Indiana, decided a few years back. And it upheld Indiana's voter ID law in spite of the fact that there was no evidence of in-person voter fraud being a problem in Indiana, and in fact there's little evidence of it being a problem anywhere else. And so it's been called a solution in search of a problem. Having affirmed the right of states to adopt voter ID laws, this Supreme Court's not going to turn around on that. Now, that does not mean that states that are covered, have covered jurisdictions under Section 5 can enact voter ID laws. Those states are under a higher scrutiny and have to show that there's not going to be regression when it comes to protection of the right to vote for racial minority groups or protected groups under the Voting Rights Act. And so that's part of the reason why this battle is important to retain Section 5. I don't think that the federal government's role in this is going to be determinative. I think it's a question of whether, except, if, as you say, it's struck down, whether there's some other kind of compromise that could be reached. I'm not sure whether there would be a lot of compromising in this Congress on this kind of issue if it's struck down by the Supreme Court. I think that that this Congress, particularly the House leaders, have shown that they're not interested in a lot of compromise, particularly on issues like this, because they see political advantage in these voter ID laws.
Most people are either unaware of the voter ID legislation laws, or they don't really think that it matters too much. Why do you think that the average Joe should have any kind of care for this?
We do have a duty or responsibility, I think, to vote. It's not that they can do anything if we don't vote, but certainly those of us who want to vote should not be prohibited or kept from voting. Jury service is another duty of citizenship, and those two things are linked. We draw juries from the voter registration rolls. When we talk about the over-incarceration of African Americans, you see the importance of jury service and also of the right to vote. But everyone should care about the right to vote if we are a true democracy. That's what we say we believe in. And whether we believe in it or not, I think is demonstrated by how much we do to protect that sacred right.
If Section 5 is struck down, do you think that we'll see immediate changes, or how long before something drastic enough to make it come back to Congress do you think will happen?
Well, I'm not sure if Section 5 is struck down. I'm not sure what will happen. One of the things that theoretically could happen is that Congress goes back to the drawing board and comes up with another formula for Section 5 coverage. Okay. But once it's struck down by the Supreme Court, if that's what happens, as I was indicating a few minutes ago, there's less of an imperative for Congress, or for some members of Congress, to reenact the Voting Rights Act. A lot of them will simply say, just let it die. It's at least Section 5. That's what I'm talking about, Section 5. It served its purpose. That kind of discrimination ended a long time ago. And yes, we have problems now. But there are other things that people are talking about that are related. So, for example, there are people that are talking about protecting the right to vote itself in the Constitution, more broadly speaking. So, for example, if you were asked whether there's a right to vote protected in the Constitution, you'd probably say yes. Am I right?
Yes.
And I tell you, the answer is pretty much wrong, with the exception that you can't discriminate on the basis of race. That's the 15th Amendment. You can't discriminate on the basis of gender. That's the 19th Amendment. Okay. But otherwise, you have to go and look at the Constitution, and you can search and search, and you won't find a general right to vote. Now, we believe that we have that right, and we do, in the sense that everybody assumes that we do, but it's not explicit in the Constitution. And so some people are talking about making it more explicit. Some people are talking about a whole range of other things to do that are related to the right to vote, and things that relate to what happened in Florida in 2000 and what we've seen in Ohio, subsequently in other states and jurisdictions, to give more protection to the right to vote. I don't think that people are going to give up on the right to vote, no matter what the Supreme Court says, but we may not see Section 5 again if they strike it down.
Well, thank you very much.
Nice meeting you.
Nice meeting you.